call this meeting of the Anchorage Assembly to order.
That's okay.
Madam Clerk, could you please take the roll?
Yes, Mr. Chair. Mr. Dunbar.
Here.
Mr. Wellington.
Here.
Mr. Constant.
Here.
Mr. Dyson.
Here.
Ms. Kennedy.
Here.
Ms. LaFrance.
Here.
Mr. Perez-Verdia.
Present.
Mr. Peterson.
Present.
Ms. Quinn Davidson.
Here.
Mr. Rivera.
Present.
Ms. Zalatel.
Here.
You have a quorum.
Thank you. Ms. Ennis, would you please lead us in the Pledge of Allegiance? I think we'll fat. Oh, that way? That's that way? Okay.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, is there anything else we need to do before going into executive session now?
Yes, Mr. Chair, I believe the municipal attorney will be laying the foundation for you, and then we'll probably ask for a motion.
Okay. Mr. Sherwood, if you would.
So pursuant to Anchorage Municipal Code 2.30.035B1, the Assembly may recess to meet in executive session to discuss a specific legal matter, including pending litigation, which is subject to attorney-client privilege. In this particular instance, recent Superior Court and Regulatory Commission of Alaska legal matters relating to the pending sale of municipal power and light to Tugatch Electric Association. All information shared and gleaned in the session is confidential. Under our code, no official action may be taken in executive sessions except to give direction to an attorney or labor negotiator regarding a specific legal matter or pending labor negotiation. The session shall be taped. Tapes will be available to members of the body and authorized staff only and may be discussed only in further executive sessions. The tapes become public at the date specified by the Assembly at the conclusion of the executive session in accordance with the code. Any discussion which occurs at this executive session should only be discussed by this body in future executive sessions. Any member who needs to leave during this session may leave, but only be updated on the discussions after the member's departure in a subsequent executive session or by way of review of the tapes of this session. Special invitees, employees, and staff members that the body determines are necessary to the conversation may remain in the meeting during the executive session. The Ethics Code states that no public servant shall use, disclose, or release confidential or non-public information gained through the person's municipal position unless authorized by law or order of the court. Any violation would be referred to the Board of Ethics. The code provides that the board may make reasonable recommendations for corrective action. In the past, corrective actions have included financial penalties and other professional consequences. Additionally, the municipality may pursue a civil action against an official where the release of confidential information adversely affects the outcome of litigation or negotiations or leads to increased financial liability. Such a disclosure could also subject a member of this body to a recall election. Pursuant to state statute, grounds for recall include misconduct in office, incompetence, or failure to perform prescribed duties. A violation of municipal confidentiality obligations would meet this criteria. The code does not specifically provide for the collection and destruction of notes taken at an executive session, but in the past, it's been a municipal practice to assure the confidentiality of discussions in executive session. If you'd like afterwards, I can or the clerk can collect and destroy the notes. If you elect to take notes and retain them, please remember that they are confidential, and failure to properly preserve their confidentiality could implicate the same consequences set out in this introduction. So at this point, members of the Emily, go ahead.
Jason, would you like to? The administration discusses ahead of time, and there's a portion that is public. So I wondered if we could do that public portion first. Unfortunately, we weren't able to inform Mr. Sherwood of that decision. But the public portion, and then we would still want to go to executive session for attorney-client.
Okay, let's do that then. So, Mr. Bockenstadt, do you have some public comments?
I believe I will let Dean Thompson, our regulatory counsel for this, just provide just kind of a general procedural update on what exactly was filed, what was the response from the RCA, and then just kind of let him talk a little bit about that, and then we can go into executive session.
Great.
Okay, good afternoon. My name is Dean Thompson. I'm with Kemple, Huffman & Ellis. I serve as outside regulatory counsel for ML&P and the municipality of Anchorage. And where we are with regard to the sale of ML&P to Chugach is in October of last year, after or before a hearing, all of the parties in that RCA approval docket entered into a settlement agreement, a stipulation that would provide for approval of the transaction, what I'll refer to as the transaction, approval of the sale under some revised terms and conditions that we presented to you at that time. There have been minor amendments to that settlement agreement, and they've been filed with the RCA. And there is one party in that docket, the Attorney General's office, who has not joined in that settlement agreement. So what is before the Commission now for review and hopefully approval is that settlement agreement that would result in the sale of ML&P to Chugach under the terms and conditions that were presented to you last fall. As part of that, there is another settlement agreement that would dispose of the pending appeal and remand from the Anchorage Alaska Superior Court with regard to the allowance of Plant 2A costs in ML&P's rates, which would also be recoverable in Chugach's rates after the transaction. And this, the RCA scheduled a status conference this morning to address the status of both of those dockets, those settlement agreements, and the procedural schedule to go forward. The date, February 28th of this year, is the statutory timeline for the RCA to rule on the settlement agreement that would authorize the sale of ML&P to Chugach. So that is where we are procedurally now, and I think in executive session we'll talk about some of the nuances of that and legal strategic issues that relate to those two settlement agreements.
Thank you. Anything else from the administration before we go into executive session? Mr. Wells?
So we should wait on questions till after.
I'm not sure. It depends on if it's something that, what I just talked about is public, just where we are in the procedure. I think what we're going to get into in executive session are more legal strategy types of issues. So I guess it depends on what
Okay,
the
so
nature
there
of the
were 2
question
points,
is.
and how did they come about? I'm sorry.
Pardon me?
So there are 2 points.
There are two related settlement agreements, and together we have asked for those agreements to be approved by the RCA, and if they do approve them, that will be RCA approval of the sale of ML&P to Chugach.
And one was the cost of Unit 2A.
Yes. And the two settlement agreements, I'll say, is the transaction settlement agreement that specifies the terms and conditions of the sale to Chugach. And as part of that, in order to get all of the parties to agree in that settlement agreement, there is a settlement of a related docket, and that docket is that Providence, after ML&P prevailed in the rate case, they appealed to the Superior Court. The Superior Court remanded it on 2 points for the Commission to consider, and ML&P and Providence were on opposite sides of that, and in order to get agreement of all of the parties in the transaction settlement agreement, we also settled that docket.
Okay, good. Gotcha.
Thank you, Mr. Wells. Ms. LaFrance?
Thank you, Mr. Chair. So the February 28 ruling date is still firm?
It is as of now, yes. Subject to, the RCA can always extend that by 90 days if they issue an order finding good cause, but they rarely if ever do that, because they also have to report that and justify it to the legislature.
Okay, thank you.
Thank you. All right, seeing no further questions, I entertain a motion to enter executive session.
So moved.
All right. Do we take a vote on that or not?
You need to see if there's any objection, so yes.
Yeah, any objection to moving into executive session? Okay.